Mr. Chairman.
Getting to you. Hang on. 1 second. Just making sure we got our act together. Do we have our act together? Okay. Mr. Reed.
Good final morning, Mr. Chairman. Joe Reed on behalf of Dominion Energy. Just a procedural matter. Yesterday afternoon, we had asked that the witness order for today begin with Mr. Pruitt and then conclude with Mr. Byrne. For reasons that I don't think I need to go into unless you want to hear them, we would ask that that order be reversed and that Mr. Byrne begin today. And we'll finish with Mr. Pruitt. I haven't had a chance to mention this to all the parties, but I have discussed it with ORS, and they have no objection to reversing that order.
That's fine.
Thank you, Mr. Chairman.
On that hopeful note of this being the last day, like I told Mr. Elliott one time, I just wouldn't make any rash statements. I don't know. You never know so far.
Good advice, Mr. Chairman.
Thank you.
Chad Burgess on behalf of SC&G. Yesterday, Ms. Walker made a statement that Mr. Addison had overruled her position with respect to research and development tax credits and that those tax credits were taken below the line to the benefit of shareholders. I wanted to just inform the Commission that that statement's not correct. In October of 2016, the company made a filing with this Commission seeking an accounting order with respect to the treatment of those R&D tax credits, and I would ask that the Commission take judicial notice of its administrative file. That file is docket number 2016-373E, and also I would ask that you specifically take notice of the order that this Commission granted the relief requested by SC&G. That order is number 2016-820. And in that order, the Commission specifically recognized that the R&D tax credits would be taken for the benefit of ratepayers.
Okay, we will take judicial notice of both of those. Thank you.
Good morning, Mr. Chairman. David Balser on behalf of SCE&G. At this time, SCE&G would call Mr. Stephen Byrne. Good morning, Mr. Byrne.
Good morning.
Could you please state your name for the record?
My name is Steve Byrne.
Are you currently employed?
I'm not.
Were you formerly employed by SCE&G?
I was.
What was your position with SCE&G?
I was the president of generation and transmission and the chief operating officer for SCE&G.
Were you deposed in connection with this matter on August 14th, 2018 and October 23rd, 2018?
I was.
Do you have any changes or additions to your deposition testimony other than the errata sheets that were previously filed with respect to the August 14th deposition transcript and the errata sheet filed this morning with respect to the October 23rd deposition?
I do not.
If you were asked all the questions contained in your deposition transcripts here today, would your answers be the same other than those reflected on the errata sheets?
They would.
Mr. Chairman, at this time, I move that the deposition testimony of Mr. Steve Byrne from his depositions on August 14th, 2018 and October 23rd, 2018 be read into the record as if given orally from the stand.
Mr. Byrne's transcripts of his depositions from August 14th, 2018 and October 23rd, 2018 will be read into the record as though given orally from the stand.
Mr. Chairman, I also would move into the record as the next composite hearing exhibit, Exhibits 1 through 40, which were attached to Mr. Byrne's August 14th and October 23rd depositions.
The Exhibits 1 through 40 attached to Mr. Byrne's testimony will be hearing Exhibit 161.
Thank you, Mr. Chairman. Mr. Byrne, have you prepared a summary of your deposition testimony in these proceedings?
I have.
Would you please deliver the summary at this time for the Commission?
Certainly. Good morning, Chairman Randall and members of the Commission. My deposition testimony in this matter covers a broad range of topics related to SCE&G's construction of nuclear reactor units 2 and 3 at the V.C. Summer Nuclear Station, including the owner's decision to undertake new nuclear construction, the issues the project faced over time, steps the owners took to mitigate and address those issues, the progress made on the project, the disclosures made to the Office of Regulatory Staff and the Public Service Commission related to the project, and the status of the project leading up to and after Westinghouse's bankruptcy. I adopt and offer the transcripts of my deposition as my testimony in these proceedings. To correspond to typical practice before the Commission, I offer this brief summary of parts of my deposition. I understand that the position taken by the Office of Regulatory Staff in these proceedings is that SCE&G should not be permitted to recover any costs incurred after the company's petition filed with the Commission on March 12th of 2015 under docket number 215-103 Echo. In light of ORS's position, my summary will be focused on the revised costs and construction schedules the owners received from the consortium in the third quarter of 2014, the work the company did to analyze those schedules, and the company's petitions for updates to the cost and construction schedule filed with the Commission on March 12 of 2015. I'm also here to testify regarding Bechtel's assessment of the project in 2015, the October 2015 amendment to the EPC contract, the exercise of the fixed price option as allowed under the amendment, and the company's petition filed with the Commission on May 26th of 2016. My testimony ends with a description of the status of the project in 2016 leading up to Westinghouse's bankruptcy announcement and the impact of that announcement on the project. During 2013, due in large part to delays caused by issues with submodule fabrication and delivery, the consortium, with CB&I as a new member, began working on a full rebaselining of the schedules for Units 2 and 3. The owners then requested that the consortium generate a new integrated project schedule, or IPS, which the consortium delivered in the summer of 2014. The consortium's IPS had new proposed substantial completion dates of late 2018 or the first half of 2019 for Unit 2 and 12 months later for Unit 3. The consortium described this schedule information as preliminary. The consortium later provided the owners with an updated estimate of the cost to complete the project. The owners put a team in place to gather additional information from the consortium regarding this schedule and to evaluate the reasonableness of the scenarios presented by the consortium. The NND team, which included Alan Torres, Kyle Young, Ron Jones, and their employees, vetted the schedule information to the extent possible. The NND team had the consortium generate a risk register and evaluated it with them. The register identified the risks to achieving the schedule and mitigation factors that may apply to those risks. After several months of analysis and discussion with the consortium, the owners believed the earlier completion dates were not appropriate and concluded, as did the consortium, that the forecasted completion dates of June of 2019 for Unit 2 and June of 2020 for Unit 3, while subject to successful mitigation efforts, were the best dates to present to the PSC. In its March 12, 2015 petition, SCE&G requested that the Commission approve these revised completion dates. In testimony submitted to the Commission, I expressly identified that the schedules can and almost certainly will change. I also testified that the consortium was not achieving the productivity factors, or PF, that it used in its schedule estimate, and it would be a substantial challenge to achieve this PF. Late in August of 2014, the owners also received the consortium's revised estimate of the cost to complete the project, referred to as an EAC. A separate N&D team was put in place to evaluate the consortium's EAC. I recall that this team was to evaluate the costs claimed by the consortium for accuracy, issues of entitlement, or determining whether the consortium was claiming costs that they were not entitled to recover under the provisions of the EPC contract, and other information useful for negotiation purposes. One of the assumptions on which the consortium's revised EAC was based was that the consortium would achieve a to-go PF of 1.15. The consortium explained that they could improve performance through, among other things, lessons they learned from China, design finalization, and the fact that the workforce was becoming more familiar with nuclear construction. As part of their review, the NND EAC team ran a scenario using the historical PF at the site. which was 1.41. My understanding of the purpose of this analysis was consistent with prior commercial negotiations with the consortium to arm senior management with negotiating points. It was not to conduct an alternate bottoms-up EAC analysis. The NND EAC team also recommended denying certain claims of costs and entitlement. In its March 12, 2015 petition, the company requested approval of an updated cost schedule based on the consortium's commitment to achieve a PF of 1.15. The company decided to use the consortium's projected PF rather than an EAC based on historical productivity for multiple reasons. First, through the company's analysis, it understood that the consortium had dedicated substantial resources to their preparation of the EAC as the contractor had the best information available to determine a projected cost over the coming 4 to 5 year time period. Second, requesting costs that were in addition to what the contractor said it would achieve would be considered a contingency which the company's attorneys understood as barred by the South Carolina Supreme Court. Third, the company did not want to relieve the consortium of its obligation to try to attain the 1.15 PF. Rather, it was in the company's interest and the interest of the ratepayers to keep pressure on the consortium to achieve what it was promising and to dispute the consortium was entitled to any additional costs resulting from its failure to achieve the estimated productivity levels. In its testimony before the Commission, the company informed the Commission of the significant challenge the consortium had set for itself in achieving a PF of 1.15 and of the risk the consortium would not improve productivity. In particular, I testified that the consortium had not met initial or revised productivity estimates to date, that the possibility that the consortium would fail to meet its productivity assumptions represented an important risk both to the cost forecast and construction schedule, that the consortium had set itself a significant challenge as to future productivity, that to achieve the proposed schedule, the consortium must improve its productivity. S&G's cost estimate did not include speculative or unitemized costs, such as owner's contingencies, and I was skeptical that the consortium could achieve their projected efficiencies. Ron Jones also testified about the construction cost and schedule estimates. In connection with SC&G's March 12, 2015 petition, I believe the ORS had access to the NND team, including the information this team had received from the consortium. I now know that the ORS was provided with information about the PF of 1.15 used in the petition, the historical PF on the project, and the basis for the use of the 1.15 in the petition. At some point in time, Santee Cooper raised the idea that Bechtel do an assessment of the project. Ultimately, the owner's outside counsel, George Winnick, engaged Bechtel. I attended Bechtel's October 22nd of 2015 preliminary presentation. I was surprised to see a project schedule in the presentation because Bechtel was not asked, to my knowledge, to rebaseline the schedule, and I did not think that Bechtel had sufficient time or information to do so. Bechtel also acknowledged during the presentation that they would need to do much more work and a deeper dive to provide a schedule the owners could rely on. The October presentation included a warning from Bechtel that the owners should not rebaseline the schedule based on Bechtel's assessment. For these reasons, among others, I did not find Bechtel's schedule useful or reliable. In addition, shortly after the Bechtel presentation, SCE&G and other companies, specifically Fluor, Westinghouse, and Southern, were to re-examine virtually all aspects of the project through an initiative called Project Bluefin, a 2-month effort that took place at the end of 2015. I was also concerned that Bechtel was motivated in part by a desire to get more permanent work on the project. Bechtel had made references to their experience working as owner's engineer in prior meetings with the owners and attempted to pitch for additional work on the project after the October presentation. Additionally, Bechtel offered to scan as CEO to send hundreds of their personnel who had completed work on another project to work on the VC Summer project. I did not believe, however, that hiring an owner's engineer would be beneficial to the project. After the October presentation, I do not recall receiving a copy of any draft Bechtel report generated in November of 2016 and do not recall receiving the final project assessment report until late February of 2016 after the owner's attorneys had received it. I do not recall receiving a separate schedule assessment report prior to the abandonment. By the time the project assessment report was received by the owners in February of 2016, SC&G had executed an amendment to the EPC contract which mooted many of the issues Bechtel identified. The amendment was executed on October 27th of 2015, just after Bechtel's October 22nd presentation, and was the primary focus of my attention during the months of September and October. I did not believe that the final Bechtel report I received in late February of 2016 identified any significant issues that the owners were unaware of or that was not mooted by the EPC amendment. I was instructed by counsel that the Bechtel PowerPoint and final report were privileged, and I was informed that I had no authority to disclose them. The October 2015 amendment to the EPC contract was a significant event in the life of the project. It was brought about because of CB&I's desire to exit the project. That gave the owners leverage to renegotiate portions of the EPC contract. One of the biggest changes in the amended contract was the increase in liquidated damages and addition of a bonus for on-time completion that would incentivize Westinghouse to finish on time. Another change was to revise the definition of change in law, which limited the circumstances under which Westinghouse would be allowed to issue a change order and impose additional costs on the owners. CB&I's exit from the project also allowed Westinghouse to take sole responsibility for construction and hire Fluor as the construction manager. As part of Project Bluefin, Fluor, Westinghouse, Southern Company, and SCE&G immediately started evaluating ways they can improve efficiency on site and implement better construction processes. Fluor was also going to do a review of the schedule to determine the extent of the mitigation needed to achieve the targeted completion dates. Fluor's involvement was seen by SCE&G as very positive for the project. SCE&G had worked successfully with Fluor in the past. The October 2015 amendment also provided the owners the option to fix the price of the EPC contract. In evaluating whether to elect the fixed price option, the owners considered information coming from the site showing that with the mitigation that Fluor was implementing, it was going to cost more money to hire more workers to complete the project on time, making the fixed price a desirable option for the owners. In November of 2015, SCE&G updated the Commission on the October 2015 EPC amendment agreement in an ex parte briefing. In the briefing, in addition to the details of the agreement, the company outlined concerns with the shield building modules being fabricated by Newport News Industrial, or NNI. I testified that the NNI delivery schedule at the time did not support the proposed substantial completion dates and that improvement was necessary. I also testified that completing the units on time was going to be a big challenge. In May of 2016, SCE&G filed another petition with the Commission requesting approval of the decision to exercise the fixed price option. The company also requested approval of the revised substantial completion dates included in the October of 2015 amendment, extending completion of the units to August of 2019 for Unit 2 and August of 2020 for Unit 3. With respect to the revised completion dates, my testimony to the Commission in 2016 expressly identified that meeting the schedule would require a great deal of construction management skill, meaning there was still risk in the schedule, and that mitigation would be necessary to achieve the completion dates. I also testified about the historical and estimated productivity factors, about the most likely PF for the entire project, and how productivity estimates weighed in favor of the fixed price option. I additionally testified that shield building panel delivery had improved, that Westinghouse would have to invest hundreds of millions of dollars in schedule mitigation, that Fluor was implementing Project Bluefin initiatives, that Fluor's initial efforts were positive but clearly not enough to solve the current schedule and productivity issues by themselves, and that Fluor recognized this and was in the process of hiring a significant number of craft and staffing a night shift with 1,000 workers. The testimony submitted to the Commission in 2016 also identified the benefits of the fixed price option in that it would incentivize Westinghouse to improve productivity and shift the risk of any increased cost due to inefficiency to Westinghouse. ORS also testified extensively about its view of the project schedule, its achievability, and other matters during these proceedings. In 2016, after the fixed price was authorized, I saw that hiring and activity levels in the project were picking up. By the end of 2016, Fluor had hired over 1,700 new craft workers, a significant increase in the craft workforce. A number of first-of-a-kind issues we encountered early on were behind us. The shield building panels were now meeting schedule requirements, and all structural modules for Units 2 and 3 had either been placed or were fabricated and on site. And Westinghouse had every incentive to complete the units on time. Westinghouse also stated repeatedly to the company that they were committed to completing the units by the targeted completion dates. I specifically recall a meeting on August 5th of 2016 that included representatives from Fluor, Westinghouse, and ORS and their attorneys, in which Westinghouse stated that its success at VC Summer was critical to Westinghouse's opportunity to sell AP1000s around the world, and that the target schedule was achievable subject to successful mitigation. I do not recall learning that Westinghouse was going to declare bankruptcy until March of 2017, just before they actually declared bankruptcy. In my opinion, had Westinghouse not gone into bankruptcy, we would still be constructing the project today. This concludes my summary.
Mr. Chairman, at this time, Mr. Byrne is available for cross-examination and questions from the commissioners.
Thank you. Mr. Guile.
Mr. Chairman, if I may, I'd like to defer to ORS to go first.
ORS.
Good morning, Mr. Chairman, Commissioners, Mr. Butler. Again, Jim Cox from the Weich Law Firm in Greenville, appearing on behalf of the ORS. Good morning, Mr. Byrne.
Morning, Mr. Cox.
Mr. Byrne, it's correct that you're here today with your personal criminal legal counsel. Is that right?
I'm here with my personal attorneys, yes.
And your personal attorneys specialize in criminal law. Is that correct?
As far as I know.
Okay. And the SCAN is paying for your legal representation. Is that correct?
My understanding is that the indemnification agreement with SCANA is covered through an insurance policy.
And the premiums for that policy is paid by SCANA, correct?
I'm not sure.
You don't pay them?
I don't pay them.
Okay. Let's talk about that 2015 amendment, Mr. Byrne. Isn't it true that SC&G essentially told the public and this commission that the 2015 amendment to the EPC contract was an offer it couldn't refuse, right?
I don't remember using those words, no.
What SC&G was saying was that the amendment shifted costs and risks to Westinghouse. What's not to like about that, right?
SC&G did testify that the EPC amendment would shift cost and risk to Westinghouse.
But isn't it true that SC&G knew at the time that that amendment was actually too good to be true?
No, I would not agree with that.
And by that I mean that SC&G knew that it was entering into a contract amendment that created a substantial risk of Westinghouse ultimately rejecting the contract and making it economically impossible to continue construction after billions of dollars more had been spent on the project.
Was that a question?
Yeah. Would you agree with that characterization?
No, I would not agree with that characterization.
Wouldn't you agree, Mr. Byrne, that given the poor state of the project in 2015 that was shown by the Bechtel assessment and that was already known by SC&G, the fixed price option is what was needed to extend the life of the doomed project and keep the earnings up for stockholders?
Could you repeat the question?
Sure. Isn't it true that given the poor state of the project in 2015, which was shown by the Bechtel assessment, which was known by SC&G, the fixed price option was used to extend the life of the doomed project and keep the earnings up for stockholders?
Well, first off, I wouldn't refer to the project in 2015 as a doomed project by any means. The 2015 amendment was brought about by the desire of one of the consortium partners to exit, which gave the owners the leverage that they needed to negotiate something new with Westinghouse. So before that time frame, that leverage or that opportunity did not exist.
Let's talk about what SC&G negotiated in that amendment. And I want to look at the clues that SC&G had at the time of execution of the amendment and right afterward, that it was executing a contract in which Westinghouse was at real risk for bankruptcy. Let's talk about the first clue. The sensitivity analysis that SC&G had run in October of 2015 showed that the fixed price option would likely reduce the total payments made by the owners to Westinghouse for completion of the project, didn't it?
The sensitivity analysis that you're talking about that was presented to the commission in 2016?
No, I'm talking about the internal sensitivity analysis that was presented to the owners by Kevin Kokums in early October 2015.
Which sensitivity analysis are you talking about?
You don't recall a sensitivity analysis that was done by Kevin Kokums that depicted the change in cost that the owners would experience by moving from the existing EPC contract to the 2015 amendment?
The company has run multiple different scenarios and multiple sensitivity analysis, so for me to comment on a specific one, I'd like to see which one it is.
Okay. So you don't recall that the sensitivity analysis that Mr. Kokums presented to the owners showed that the change to the fixed price option would reduce the cost of the project to the owners by billions of dollars?
I'm not sure that I recall a sensitivity analysis done by Mr. Kokums that showed that. There was a sensitivity analysis done in support of the fixed price option determination that was done by Mr. Lynch that was submitted as part of the proceeding in 2016.
And is it correct that Dr. Lynch's sensitivity analysis that was presented to the Commission in 2016 showed that the change to the fixed price option would likely only result in a reduction of cost to the owners of $800 to $900 million?
I don't know that your characterization is necessarily accurate. What Mr. Lynch did was run a sensitivity analysis that had, I think it was 20-some outcomes. In a majority of the outcomes, in a vast majority of the outcomes, the selection of the fixed price option under that sensitivity analysis would have showed a benefit to the company and its customers. In a minority of those sensitivity analysis would have shown that electing the fixed price option was not favorable.
And that sensitivity analysis, Mr. Byrne, isn't it true that the majority of the outcomes showed that the benefit to the owners by the move to the fixed price option would be around $800 to $900 million?
Could you repeat that question?
Sure. Isn't it true that Dr. Lynch's sensitivity analysis showed that the most likely result of moving to the fixed price option would be a benefit to the owners of about $800 to $900 million in contract cost?
I don't recall that it was a majority. I don't recall it being the most likely. I do recall that there was, at the top end of his sensitivity analysis, was a number that sounds familiar with what you just discussed in that $800 to $900 million range, whether there was a spectrum of results.
So you don't recall, Mr. Byrne, that Mr. Kokums' sensitivity analysis that was presented to the owners, not to the Commission, showed that if you accept a 12-month delay in the completion dates of the units, the net gain to the owners in moving to the fixed price option would be between $2 and $3 billion.
I don't remember what you're talking about.
Okay, and that's just with a 12-month delay. Isn't it true that if the delay in completion of the units, if you accept the Bechtel assessment of the schedule of around a 24-month delay, then the net benefit of moving to the fixed price option would be even greater than with only a 12-month delay in completion?
Was there a question?
Isn't it true?
Could you repeat that question?
Sure. Let me give you an assumption. The assumption is that that if you accept a 12-month delay in the current or the then existing substantial completion dates for the units under the schedule that the consortium had at that time, that the benefit to the owners of moving to the fixed price option would be between $2 and $3 billion. Wouldn't you agree that if you assumed an even greater delay in completion of around 24 months, such as the Bechtel assessment showed, the benefit to the owners of moving to the fixed price option would be even greater than that $2 or $3 billion?
Well, without validating your numbers, it would be true to say that a longer delay would cost more.
And under the fixed price option, there would be no increase in the cost to the owners. Is that correct?
The short answer is it would depend upon whether or not it was something that would be legitimately charged to the owners under a change order, which the owners worked very diligently to limit.
So we've talked about the extent of the cost to the owners, and isn't it fair to say, Mr. Byrne, that a change in the cost to the owners, a benefit of the cost to the owners, is going to equal a corresponding reduction in revenue to Westinghouse? Is that correct?
You said a change in cost to the owners would result in a decrease in revenue to Westinghouse?
Yeah, let me rephrase the question. Isn't it true that if the change to the fixed price option for the owners, a reduction in the cost of construction, would equal a corresponding change in decrease in revenue going to Westinghouse from the owners?
I'm not sure I'm understanding the way you're asking the question. You said a decrease in cost of the construction. A decrease in cost of construction would result in an increase in the money going to Westinghouse.
A decrease in cost to the owners under the fixed price option.
Well, understand that the fixed price option was a fixed price, so there wasn't going to be a decrease in cost to the owners.
And fair enough, Mr. Byrne, I'm comparing it to the cost that the owners would have incurred under the 2008 EPC contract, the pre-fixed price option contract. If you assume that there is a decrease in cost to the owners in moving to the fixed price option, then there's going to be a corresponding amount of decrease in revenue going to Westinghouse by that move.
So I think what you're trying to outline is exactly the reason why the owners negotiated so hard to get the fixed price option, and it was to limit the ability of the consortium or Westinghouse to recover costs, some of which the owners didn't think that they were entitled to recover, and it settled all of those costs and did a number of other things. Westinghouse had explained to me and had explained to the owners, and I believe maybe even our Office of Regulatory staff, that they understood that this project was vitally important. The U.S. projects, first ones built under Part 52 in this country, were vitally important to their efforts to sell this design, the AP1000 design, around the world. And to me, the Westinghouse officials said that they were going to lose money on this project. So first off, we knew that they were going to lose money on the project, or we thought that they were going to lose money on the project. Secondly, we did pay roughly a $500 million premium to Westinghouse over their estimate to complete costs that they had in that 2015 agreement to get the fixed price option. So we did pay them a premium to get that fixed price option.
And isn't it true, Mr. Byrne, that you took them at their word on that without getting any contractual assurance in writing with respect to their promise that they would get the job done?
No, I don't think that's the case at all.
Okay. Let's move on, and we'll come back to the guarantee that you say exists. The first point we talked about was the size of the losses that Westinghouse would experience under the contract. Isn't it true that during the first year of the fixed price option, the owners would be paying large lump sum payments of $100 million per month, sometimes even more than that, in advance of the actual work being performed?
You said for the first year? That's not accurate.
During the first year.
During the first year, okay. So starting, I think it was in January of 2016, the owners had agreed to make payments to Westinghouse in the form of $100 million a month in lieu of the other payment mechanisms in order to fund their expansion on the project, to bring on Fluor as a subcontracted construction manager, and to expand the workforce at Fluor that was going to need to be done. So it was an effort not to handicap the project. So, go back to end of 2015, the first part of 2016, things were changing. We had a new contract. A number of the issues that were plaguing the project, particularly with equipment and materials, were behind the project. The submodule deliveries were coming in. Fluor, coming in now as a new subcontract construction manager, had recognized the need to staff up. They had gone through this Project Bluefin, where they were looking at a number of different work streams in order to improve it. So in order to fund the improvements and staff up to the levels that Fluor wanted to staff up to, the agreement was struck between the two owners and Westinghouse that they would make payments of $100 million a month, while a project milestone schedule payment-based program was being negotiated.
And sometimes those payments were greater than $100 million a month in 2016, correct?
I believe there were a couple of months near the tail end of that portion where they were greater than $100 million a month.
And ultimately, the owners made 9 of those payments throughout the course of 2016, correct?
I don't remember the exact number, but that sounds about right.
And these upfront payments, isn't it true that these upfront payments exceeded the cost that Westinghouse was incurring at that time under the contract?
Well, I don't think it exceeded the cost that Westinghouse was incurring at the time. What it exceeded was the cost that Westinghouse would have been entitled to invoice the owners for.
And isn't it true that the amount that Westinghouse would have been entitled to invoice the owners for was the actual cost under the pre-existing contract?
Under the previous contract, yes. Under the new contract, they were going to a milestone-based payment schedule. But until that schedule had been negotiated, there was an agreement to pay them the $100 million a month.
And sometimes more, right?
And in the latter portions of that, it was higher than that. Yes.
It was $130 million a month, some months, right, Mr. Byrne?
I believe that's the case.
And that amount was greater than the amount that Westinghouse would have received on the 2008 contract, correct?
That amount would have been greater than the amount under the old contract. That's correct.
And isn't it true that Westinghouse was not ramping up staffing as the owners anticipated after the fixed price option was executed?
I think that Fluor did demonstrate that they went to great lengths to increase staffing. I think over 2016 they increased staffing of the craft by something like 1,700 people. So no, I would disagree with that characterization, and I would say that Fluor was kicking off a number of efforts. Now, perhaps they got off to a slow start in the first month or two of 2016, but their efforts to hire staff were really significant in that year.
I'd like to take a look at an email between you and Michael Crosby from Santee Cooper. Michael Crosby was essentially your counterpart at Santee Cooper as part of the ownership group on the project, correct?
He was.
Okay. May I approach the witness? Mr. Byrne, this is an email dated March 15, 2016, between you and Mr. Crosby. You can review the document. I'd like to turn your attention to a chart that's on the 3rd page of the document. Isn't it true, Mr. Byrne, that this chart on the 3rd page of this email between you and Mr. Crosby shows that after the first 2 months of the fixed price option that the overpayment to Westinghouse for work actually performed was more than $120 million?
The overpayment based on the old contract provisions for what they would be allowed to invoice was that much at that point in time.
And Mr. Crosby expresses concern to you about this issue, doesn't he?
He does.
And I'd like for you to take a look at the top of this third page of the email. There were a couple points in your summary, Mr. Byrne, where I thought your terminology was a bit artful about using the term "I do not recall." For example, in the last paragraph of your summary, you state, "I do not recall learning that Westinghouse was going to declare bankruptcy until March 2017, just before they actually declared bankruptcy." Isn't it true that the owners had a real concern that based on the 2015 amendment, Westinghouse could declare a strategic bankruptcy, and that concern existed a full year before the bankruptcy was actually declared?
I think that the owners, from a contingency planning perspective, were looking at things like that, even in the original negotiation of the EPC contract back in the 2006, 7, and 8 time frame.
What about 2015? They didn't do it then, did they?
They didn't do what?
Address the concern of a strategic bankruptcy.
Who didn't address a concern of a strategic
The owners did not address a concern of a strategic bankruptcy in the 2015 amendment.
Specific provisions you're talking about in the 2015 amendment to the EPC contract?
Right. Or any other protection, Mr. Byrne, against a strategic bankruptcy.
Yeah, I don't recall anything along those lines. There were provisions in the original contract that called for performance bonds, which had been exercised, called for intellectual property be escrowed, which had been exercised, and there were parental guarantee language. And I do know that our attorneys wanted Toshiba to re-up for the parental guarantee as a part of that EPC amendment in 2015.
And that parental guarantee turned out to be insufficient to keep the project going after bankruptcy was declared. Isn't that correct?
Well, I think it was the cost of the project to complete that proved to be the cancellation of the project. The fact that the parental guarantee existed, I don't think that in and of itself was going to make or break the project. And the parental guarantee amount was actually de facto increased in this amendment because that parental guarantee amount applied to what had been a percentage of what had been paid under the fixed and firm portions of the contract. So when you take the entire contract to fixed and firm, it increases the amount of money that is now being guaranteed.
It is correct to say, though, that the parental guarantee did not make it economically efficient to continue construction of the project after Westinghouse declared bankruptcy.
I think it would be accurate to say that the parental guarantee did not cover the full amount of the cost estimated to complete the project after the Westinghouse bankruptcy.
And let's take a look at the top bullet point on this third page of this email where Mr. Crosby is emailing you. And he says, quote, "Does the exercise of the fixed price option make it more likely that Westinghouse will pursue a strategic bankruptcy in order to have the bankruptcy court reject the he says ECP, I think he means EPC agreement," end quote. And you received this email, correct, Mr. Byrne?
As far as I know, I did.
And isn't it true that the owners actually started trying to find bankruptcy counsel around this time in March 2016?
Yeah, the legal departments of SCANA and Santee Cooper had worked to retain bankruptcy counsel. I don't remember the timing on their retention of that bankruptcy counsel, but they were working on it.
Isn't it true that your lawyer, Winnick, actually delayed retaining counsel so that the owners actually didn't retain bankruptcy counsel until December of 2016?
I have no knowledge of that.
You don't recall?
I don't recall.
And isn't it true that this documentation of the actual work completed shows that at this point in time, Westinghouse had not met its commitment to ramp up production after the fixed price amendment was implemented.
I don't think that that's necessarily the case. I do believe that their payments to Fluor were going to be significant, that their efforts, as they said all along, what they're allowed to bill under the contract is far less than their actual expenditures because of a significant increase in workload, particularly on modules, structural modules, mechanical modules. And so their expenses at those module suppliers would not necessarily be reflected in the numbers that they were allowed to bill. And I had asked the N&D team that was looking at EAC costs and said, do you doubt that Westinghouse actually is spending the money, spending $100 million? And the response I got from them was that, no, we're not disputing the fact that they paid it. It's just an entitlement issue.
Isn't it true that at the end of the 9-month interim payment schedule that the owners believed that they were due over $200 million in true-up money because of the difference between what Westinghouse had actually spent on the project and how much the owners had actually paid?
I do recall that there was an amount of money. I don't recall the amount. There was an amount of money that the owners felt that was due under a true-up provision. Now, that would not necessarily be cash coming to the owners, but it may be a reduction in the invoice amounts for future payments. But yes, the owners felt that there would be a true-up.
Mr. Chairman, at this time I'd like to ask that this email between Mr. Crosby and Mr. Byrne dated March 15, 2016 be entered as the next hearing exhibit.
The March email will be entered as hearing exhibit 162.
Mr. Byrne, I'd like to call your attention now to another email on which you were copied in July 2016, if I may, Mr. Chairman. This is an email dated July 14, 2016 from Lonnie Carter to Kevin Marsh, and you're copied on this email. Is that correct, Mr. Byrne?
That's correct.
I'd like to turn your attention to the fourth page of this email. Now, on the fourth page of this email chain, Mr. Byrne, there's an email from Lonnie Carter to Kevin Marsh, and there's a paragraph that says, as you are aware. And I'd like to turn your attention to the fourth sentence in this paragraph. And it begins, quote, WEC has negotiated itself into the position it presently holds, has claimed but failed to show us proof that it is in financial extremis on the project, as indicated in an email forwarded to us, and has not been cooperative on negotiations over the milestone payment schedule, Danny even failing to return our calls. For a WEC official to use the term in extremis at the point of death in terms of its cash situation raises the obvious concern WEC does not have the financial wherewithal to appropriately and effectively manage a construction project of this size, and the owners will need verification that this term was used ill-advisedly. End quote, it goes on. Did I read that correctly, Mr. Byrne?
You appear to have read it correctly.
And isn't it true that the owners actually heard from Westinghouse in July 2016 that it was in extremis in its financial condition?
I don't remember the context of the use of the term, and I don't specifically remember Mr. Roderick using the term. So this is Mr. Carter's recollection, I think, of a meeting or an interaction he'd had with Mr. Roderick. You have to remember that this two things about this. One, Westinghouse was looking to justify its need for more money. And it was having significant amount of expenditures and was trying to convince the owners to cover those expenditures while we negotiated the construction milestone payment schedule. And secondly, there were a number of commercial issues on this project, basically from the start to the finish, which may not be unusual, but the magnitude of the scope of the dollars involved would be significant. So the contractual discussions, commercial negotiations were significant on this project. So all of these communications ended up being what I would call negotiation sessions, where the sides were staking out positions that were more significant, perhaps. So when Westinghouse would come with a number, the owners understood that that was a high number. It's almost like negotiating for a car. You never pay the sticker price, or you never pay the first offer that the dealer has, so it's a negotiation. And Mr. Roderick's use of the term in extremis was probably in negotiating posture. And I often found that Mr. Carter would write emails or letters or say things during meetings that would adopt a negotiating posture, and I believe that's one of the things he was doing here.
Who would do that?
Mr. Carter.
Mr. Carter is talking to his partners here, the owners, not to Westinghouse. Isn't that right?
I think Mr. Carter always assumed that whatever he was writing would find its way to Westinghouse.
So if we're talking about negotiating over a car here, we're talking about a Lamborghini, right?
Well, we're talking about a nuclear plant.
Right.
I was just using an analogy.
Okay. I
wasn't trying to infer that we were actually negotiating over a car.
Okay. And isn't it true that in this email, Mr. Marsh agrees to raise the monthly payment from $100 million to $130 million because he believes we're going to get that money back at the end of the life of the contract anyway, right?
Certainly, the owners felt like there would be a true-up, and I believe Mr. Carter did agree with the $130 million payment.
And that was Mr. Marsh's idea, correct?
I don't remember if it was his idea, but certainly Mr. Marsh was soliciting that from Mr. Carter.
I'd like you to turn to page 3 of this email, Mr. Byrne. Let's talk about the signs that the owners had that Westinghouse was not taking its obligations under the fixed price amendment seriously. The first sentence of the second paragraph on page 3 begins, quote, "This situation is made much more difficult by WEC's continued refusal to give us meaningful construction project expenditure information over the course of the now 6-month, $100 million payment period. In signing the October 2015 amendment, each party pledged through Section 12 of that document to make a good faith effort to reach agreement on a milestone payment schedule. Candidly, WEC has not done that. By failing to open its books while claiming confidentiality and proprietary protections, telling us more detailed expenditure information is unavailable because of the manpower required to produce it, and by sending us a current monthly invoice for $160 million, which is neither substantiated nor authorized in any contract language, WEC is not negotiating in good faith. We sanction that behavior by responding with an increased payment." Did I read that paragraph correctly, Mr. Byrne?
You seem to have, yes.
And this is information that you and Mr. Marsh received in July 2016, correct?
It was an email from Mr. Carter to Mr. Marsh that I was copied on in 2016.
And let's go into the next paragraph, the first 3 sentences of the next paragraph.
Let me back up just a second. It doesn't appear that I was copied on this email in July of 2016. So this, what you just read from, was sent from Mr. Carter to Mr. Marsh.
Right, and then you were added to the email chain on July 14th, correct?
I was added sometime later, yes.
Okay. The next day, actually, right?
Yes.
And let's look at that next paragraph, starting with the second sentence. Quote, the primary purpose of the fixed price option and milestone payment schedule is to incentivize WEC to get the units built. Through the last 6 months, while the owners have paid $600 million, construction progress has been an aggregate of 3%. So at this point in time, it's still true that Westinghouse still hadn't ramped up its construction efforts on the project, correct?
No, I don't know that that's the case. Mr. Carter using that one metric doesn't necessarily mean that that there was not a ramp up. As I pointed out earlier, that there's a significant effort in modules, and in general, they wouldn't take credit for a module, the hours in the module, the work in the module, until it was placed.
I'd like to talk about SC&G's knowledge at this point in time, Mr. Byrne. At this point in time, beyond knowing the facts that it knew at the execution of the amendment, which is that Westinghouse would likely take a large loss on the amendment, as well as that the owners would be paying payments in excess of what the work would be done during the first year of the project. At this point in time, the owners also know other facts, that Westinghouse is not taking its obligations seriously under the amendment to negotiate a construction milestone schedule or to ramp up its production, and it's claiming that it's in financial distress, correct?
You asked 3 or 4 things there, but I'm not sure that I would necessarily agree with some of them. So could you ask the specific things you would like me to answer so I make sure I get to all of them?
Sure. I'm going to set aside the facts that were known to the owner at the execution of the contract, as far as what the contract would entail, as far as the payments. I'd like to talk about what facts the owners learned by July 2016, as far as how Westinghouse was engaging under the amendment. So the first point is that Westinghouse wasn't engaging in good faith to reach a construction milestone payment plan, correct?
I don't know that I would characterize it that way. I can understand that Mr. Carter might use that kind of language in his frustration over the fact that the two sides had not come to agreement. Certainly, the Westinghouse came with a position, came with information and documentation, and it's just that the owners disagreed with their position, and so there was eventually reached impasse. So I don't believe that it was that they were not negotiating in good faith. It's just that the positions differed.
Mr. Carter expressed that opinion to you, correct?
I think Mr. Carter expressed that opinion to Mr. Marsh in the email.
Okay, and this is 3 months after Mr. Carter raised the issue of getting bankruptcy counsel to assess Westinghouse, correct?
I don't remember timeframes, but the contingency to look for bankruptcy counsel was raised by Santee at some point in time, and so Mr. Carter, though, also did eventually agree to make the increased payments, the $130 million payments. So again, Mr. Carter would oftentimes adopt a negotiating posture even with their partners. But I don't think the characterization that Westinghouse was not negotiating in good faith is accurate.
It's correct that Mr. Marsh encouraged Mr. Carter to agree to that payment because he wanted to motivate Westinghouse to continue discussions on a milestone payment schedule.
I don't know that to be the case. Was that language in here somewhere?
It is, but I'll move on. Isn't it true that also at this time the owners had some indication that Westinghouse was in financial distress?
I don't know that the owners had an indication that Westinghouse was in financial distress. Again, oftentimes Westinghouse would adopt a negotiating posture. So everything that you heard from the first time was discounted. So I don't know that they were necessarily in financial distress at this point in time. And they were backed up by Toshiba Corporation.
And isn't it true that at this point in time, the owners, the indication to the owners was that Westinghouse was not ramping up construction as it had indicated it would do under the fixed price amendment?
No, I think that in July, the ramp up of Craft Resources by Fluor, who was the construction manager working directly for Westinghouse, so that's a Westinghouse activity too, by its very nature, was showing significant increases.
But it's correct to say that that wasn't showing up on the project because the construction progress had only been an aggregate of 3% since the amendment had been executed, correct?
Well, I don't know that to be the case. Mr. Carter, again, would sometimes adopt negotiating postures, and I would sometimes find mistakes in what he would put in some of the emails, but it didn't seem like a point worth raising with him. Certainly, the percent complete per month is something that the owners wanted to increase, but again, the percent complete per month is just a measure of the direct craft work, and is not necessarily a measure of anything that's indirect, any work going on by subcontractors, work at vendors that was taking place that was, for modular construction, a lot of these modules are actually built off-site. Some of them are assembled on-site, but generally they don't take credit for it until the module is installed. So there were factors at work here. That's one of the reasons why Westinghouse, the consortium beforehand and Westinghouse after the consortium dissolved, would report percent complete in terms of other factors as well, of procurement, which is where the modules would be, of engineering and of startup. So that percentage was much higher.
Mr. Byrne,
Hey, we're going to take about a 10-minute break. Mr. Cox, we're beginning to repeat on the same theme here, too, so it'd be good to move it forward.